Right. There are also other convictions that can cause problems. Not just convictions, I should say, but other issues that can cause firearm ownership problems here in California. The biggest one being restraining orders. This includes civil harassment, domestic violence, elder abuse, and even what are called, of course, gun violence restraining orders, which are often referred to as red flag laws, which here in California is a GVRO, or gun violence restraining order. This is a court order that, if it's a domestic violence, civil harassment, that type of restraining order, generally orders you from orders you to stay away from a certain individual, place, that kind of thing, or to cease harassing activity in the case of civil harassment. In the case of a gun violence restraining order, it's specifically targeting a person's firearm rights. With the exception of domestic violence restraining orders, all other types of restraining orders in California are typically issued on a clear and convincing standard, meaning the petitioner has to prove by clear and convincing evidence that a restraining order of the type they are seeking is warranted. However, as I have come to learn and was expressed to me once, and it sort of stuck with me, and it's a great way of sort of thinking about it, the restraining order system in California is sort of like the Wild West of law. And what I mean by that is, it's really up to the judge. You know, how good was their breakfast that morning? Did they get up on the right side of bed? Did they get enough sleep? How do they feel about you? I have seen judges issue restraining orders in cases that should not have been issued in any way, shape, or form. I have seen judges refuse to issue restraining orders where they should have been issued. And generally speaking, judges have extremely wide discretion in issuing these types of orders. So because of that, what I usually suggest, if individuals are facing the possibility of getting their rights restricted because they're facing a restraining order being issued against them, I try and encourage the person to see about coming to what we call a sort of civil compromise, meaning you basically agree in a contractual format to whatever it is the petitioner is seeking, absent the effect of a court order. And so you can structure these however you want, generally speaking, but what it does is it dismisses the case against you, so there is no actual court order issued against you, but you're basically giving what the other person wants in a contractual form and agreeing to stay away from them or to cease certain activities, that kind of thing. This way, there's no actual court order, and your right to own or possess firearms is unaffected. The case is simply dismissed. That is one of the best possible outcomes in these types of cases, given the fact that these types of orders can be issued almost willy-nilly depending on how the judge feels. So for the most part, if you have a petition that's been filed against you, just know that that's usually the best way to deal with it. But of course it is temporary, meaning that once the restraining order is lifted or over with, the restriction on owning and possessing firearms is also lifted. So restraining orders can be issued generally up to 5 years. Typically, if they are issued, I see them usually issued for about 3. Most judges will issue them for about that time, sort of right in the middle, almost. But they can be as little as, 6 months, a couple months, depending on the circumstances. So, just depending on, how dire the situation is, how good of a case you have could change how you sort of approach a restraining order being filed against you. The other thing to understand in California, at least, is that typically, in these types of cases, temporary restraining orders are issued, or at least they can be issued, particularly in cases of alleged violence, that kind of thing, where the person says, he hit me, he shoved me, pushed me, he called me names, whatever, In those types of cases, people often do seek, and judges will often grant, temporary restraining orders, and those temporary restraining orders themselves also carry with it a prohibition on owning or possessing firearms. When you are served with a temporary restraining order, that means someone physically hands you a copy of the court paperwork. It's not just left in your mailbox, or it's, emailed to you, that kind of thing. You have to be personally served. Once you are personally served, that's when the order takes effect. And so in California, that means that if you currently own or possess firearms and you're served with a temporary restraining order, you have 24 hours from the time of being served to dispose of any firearms and ammunition you have by storing them typically with a California licensed firearms dealer or even law enforcement agency. Generally speaking, I don't recommend storing them with a law enforcement agency because it is much more difficult and time-consuming to get the firearms back if they are in the custody of law enforcement, as opposed to if you have them with a firearm dealer, all they simply have to do is basically dross the guns back to you to confirm that you're not prohibited anymore. So a little pro tip there: if you're subject to a restraining order, always try and have the dealer take the firearms away. Had to honk at that guy who's rolling backwards at me. So yeah, don't storm with law enforcement if you can avoid it. But then after you have disposed of your firearms and ammunition, hopefully with a licensed dealer, you then have an additional 24 hours, so 48 hours after being served, to have the appropriate paperwork filed with the court to notify the court that issued the temporary order that you have complied with the requirements of the order and you have dispossessed yourself of any firearms or ammunition. That's a simple form filing. In the case of a restraining order, typically that paperwork comes with the restraining order paperwork itself, and you just take that to the dealer, have the dealer fill out the relevant portion stating that they in fact took your firearms in, and you file that with the court. And then you talk about with your attorney, hopefully, what options you have to deal with the restraining order moving forward. Most restraining order cases are usually have hearings held within 21 days of the petition being filed. However, given COVID and all the other nonsense that's been going on in California, at least up in the Bay Area here, Santa Cruz County, Alameda, they have court-issued directives that have delayed those hearings for up to 3 months. So it can be a while before you actually get a formal hearing, which in the event that you have a restraining order issued against you, or I should say you don't have a temporary order issued against you, the judge for whatever reason said that this doesn't warrant a temporary order, but we should still have a hearing, that really doesn't change anything for your right to own or possess firearms, because if there's no temporary order in effect for the duration, at least until the hearing, you're not prohibited during that time period.